much in turn. I won't keep you very long, but this matter is sufficiently important for me as a physician leader to respond to in a most timely manner. I want to begin my comments to you this morning by reading for you Section 81 of the Constitution. For the simple reason that there are a lot of people who are making comments on the recent developments, and it's either that they are unaware of the contents of this section, or they choose to interpret it to suit their position, their location, their agenda, or their assignment. So let me, for the benefit of the people of Trinidad and Tobago, read Section 81 of the Constitution. The Prime Minister shall keep the President fully informed concerning the general conduct of the government of Trinidad and Tobago, and shall furnish the President with such information as he may request with respect to any particular matter relating to the government of Trinidad and Tobago. Now, that is the English language. And it doesn't matter what interpretation one puts on it. That is the letter and by extension the spirit of the Constitution of Trinidad and Tobago. Against that background, it has been common parlance in Trinidad and Tobago to hear persons, many of whom profess to be educated and in a position to advise the population, talking about a ceremonial president and a figurehead president. That has been the talk in this country for years, for decades, until we reach a situation where a day comes when the government of Trinidad and Tobago does something which angers the population of Trinidad and Tobago, and the government seeks to hide itself behind its carpet, and it seeks to interpret both through its own mouth and the mouths of its supporters and other kinds of persons the situation that has angered the public. This situation I refer to specifically one like the proclamation of Section 34. The proclamation of Section 34 of the Administration of Justice Bill is something which has angered the population. And if you read today's editorial in today's Express, there's a tacit and expressed understanding that this matter remains unresolved. That is the word used by the Express in today's publication, an unresolved matter. What is the matter that is unresolved? The matter that is unresolved is an allegation made against the government of Trinidad and Tobago, namely the cabinet, that the cabinet knowingly or ought to have known that by extricating and pulling out Clause 34 and proclaiming it, that by that action and that action alone, it would have been creating an environment where financiers known to the government would have been prevented from being dealt with by the courts of Trinidad and Tobago. Let me repeat that for all those who have comments to make on the current development. The action that we are wanting explanations from the Prime Minister for are actions where the cabinet took out a clause from a bill, from a law, proclaimed that clause, the clause having the singular effect of creating an amnesty, the beneficiaries of that amnesty being financiers of the ruling party. And the population's view is that that action was a deliberate action on the part of the government, led by a Prime Minister who carries the title of Senior Counsel, an Attorney General who carries the title of Senior Counsel, who ought to have known and who must have known the effect of that action. And therefore, two things happened in this country after that was done. One, the office of president was approached with a petition to look at the matter. At that time, the acting president was in office. He undertook some kind of activity and he made certain comments. Subsequent to that, there was still tremendous dissatisfaction in this country, even after the publication of the comments of the acting president. Whatever one thinks of the comments of the acting president, the office of president commented to the country, and subsequent to that, one of the largest gatherings of citizens in this country took place when over 40,000 persons of all shades, of all locations, came out to express a concern to the government. Subsequent to that, a body of citizens, including the opposition, trade unions, NGOs, and other bodies, 15 signatory bodies, went to the president on this occasion, the substantive office holder, and presented him with a dossier of all the conflicting information. Because by that time, subsequent to what was commented upon by the acting president, a series of valuable but conflicting comments and documentation became available to the population. We took all of that to the president and pointed out to the president that there still remains in Trinidad and Tobago a serious concern about the behavior of the cabinet, which had acted in the way it acted with respect to Clause 34, which benefited known finances of the government. So for all those who want to take the position that the acting president had acted, the acting president took a position at a particular point in time. We expressed our comments on that. That is not before us anymore. Subsequent to that, we were in a position to make a stronger case to the office of president. And on this occasion, it was not just the PNM going to the president. There are those 15 signature bodies, which included the opposition of Trinidad and Tobago, and a large cross-section of the trade union movement, and a number of NGOs, and the general sentiment in this country is that the population still does not have an answer for a very simple question put to the government. And the question is, notwithstanding how it went in the operationalization, why did the Prime Minister organize her cabinet to have Clause 34 extricated and proclaimed into law? We have not got an answer for that. So we went to the president under the constitutional provision of Section 81, which gives the president the power to request of the Prime Minister information, one may want to call it a report, information on a particular matter, where in this case, and I don't want the population to lose sight of the fact here, this is no ordinary action of the government, building a school, building a drain, not giving a grant, traveling every day. No. This is an allegation where the cabinet, headed by the Prime Minister, is being accused of undermining the rule of law and preventing its financiers from accounting in the face of criminal allegations. That is what the issue is. Persons known to the government against whom serious criminal charges could have been laid for serious allegations of criminal conduct. The cabinet is being accused of acting as a cabinet to create a situation where those persons will no longer have to account for their alleged criminal conduct. So therefore, it's not a simple matter of the Prime Minister and the supporters simply saying that we have dealt with it. Because clearly, if the allegations are being made against the people in the cabinet, it requires a certain amount of transparency in the response, so as to satisfy not just the president, but the country. So, we went to the president, and we expected that the president would have perused the documentation we placed to him, because a large amount of documentation is in the public domain. A significant amount of it is contradictory and raises questions about who did what, when, and how. And none of those answers are available to us in any sequential way, so we can understand exactly what happened, so we can hold persons accountable for this travesty that took place in Trinidad and Tobago. I presume that the President of Trinidad and Tobago would have consulted his legal advisors. And on that basis, the President would have acted, and the President did act under Section 8. I'm seeing it being reported. In fact, even before the President acted, the government's chief spokesperson, the Attorney General, sought to scare the President away from digesting the issue in front of us, on accepting the public concern, and for using his powers under Section 81. That was the Attorney General. Now that the President obviously satisfied, as the Express is, that there's an unresolved matter here, and I'm using the word of the Express editorial of today, unresolved. The President of Trinidad and Tobago satisfying himself that this very serious matter, which borders on criminal conduct, is unresolved, has put to the Prime Minister questions. I have not seen the questions, I have not seen the request, but I know what the power of Section 81 is, and I know the nature of the complaint that was put to the President. So when I am advised that he has acted under Section 81, I am now interpreting it that the President has put to the Prime Minister questions that the population should know about. Because as I speak to you now, going on the basis of what has been put in the public domain by spokespersons for the government, the population must understand that we have a crisis with respect to the operations of our Constitution. Because there are two possibilities that we are seeing here. Because the government is talking in tones and shades and shadows. One is that we are told that the Prime Minister has told the President that she has already dealt with the matter. Now, as the opposition of Trinidad and Tobago, insofar as that may be the position of the Prime Minister of Trinidad and Tobago, that the matter has already been dealt with, especially if it is done in the context of what acting President Hammersley did. We are of the view that such a position by the Prime Minister of Trinidad and Tobago, if that is her position, is a position which is unacceptable and creates a constitutional crisis. In that, the President would have asked the Prime Minister for information after he has reviewed the situation as of even date. And the Prime Minister, if she takes the position that I have nothing to say to you because it has been dealt with already, then the President has to go the whole way. And that is, it cannot be that the Prime Minister can refuse to acknowledge the President's power under Section 81 on some basis that she is satisfied that the matter has been dealt with. That is unacceptable and will not be accepted by the opposition. And the Prime Minister of Trinidad and Tobago is not above the law. Any public official in this country, whether it is an immigration officer, police officer, a medical doctor, or the Prime Minister, who has a public duty and fails to carry out that public duty, such a person is subject to an arm of the state called the legislature, called the judiciary. And that is, if a public officer fails to carry out his duty, in this case, the Prime Minister has a duty to report to the Prime Minister, to the President, and if the Prime Minister takes the position that she is satisfied that the matter has already been dealt with, that is not the point. Nobody is asking the Prime Minister whether she is satisfied. We know that she is satisfied. In fact, we know that she is involved in the proclamation. We know that she headed the cabinet that brought about the proclamation, so we will not be surprised at all if she is satisfied that the matter has been dealt with. We know that she expects that by firing one minister and asking the country to move on, that she is satisfied. That's not the point. The point is, under Section 81, she has a duty to provide the President with relevant information on this aspect of the government's conduct. And if it is, it can be confirmed that the Prime Minister is taking the position that she has nothing to say to the President because the matter has been dealt with. It is the position of the opposition that the President has no choice but to go the whole way with this office holder, albeit that the office is called Office of Prime Minister, that this office holder, the action of this office holder, be taken to the courts of Trinidad and Tobago for an order of mandamus, where the judiciary will examine the situation and would determine whether the office holder has satisfied the requirements of her office and has discharged her duty. This is a remedy available with respect to the carrying out of a duty on the part of any officer, including Prime Minister. And for us to be satisfied that this remedy, as available to us, is utilized, if it is required, or not utilized, if it is not deemed to be required, the President now has a duty under the guise of full disclosure to the population and transparency on this matter to indicate to the national population the nature of the correspondence between the President and the Prime Minister so that the population can be satisfied that the office of President is functioning appropriately and that the office of Prime Minister is functioning appropriately. I have seen in today's papers where spokespersons for the government indicating that the Prime Minister will have provided to the President documents from Hansard as proof that she has dealt with the matter. I want to draw to the attention of the national population that the records of this country will show that 3 times this matter came up in the Parliament. Once in the lower house, when the House met in emergency session to repeal Clause 34. Twice, when it went to the upper house to repeal Clause 34. And the 3rd time, when a motion of censure was filed and debated, where the Attorney General, as office holder responsible for legislation, was held accountable by the Parliament. And on all 3 occasions, the Prime Minister of Trinidad and Tobago had absolutely nothing to say to the people of Trinidad and Tobago on this matter. So any matter sent to the President from the Parliament will obviously show absolutely no comment on this matter from the head of the Cabinet, and therefore could in no way contribute to satisfying the population that the President would have received from the Parliament any explanation from the Prime Minister, because the Prime Minister studiously failed to explain to the population whatever she had to explain to us on this matter in all 3 opportunities. We, as citizens of this country, are now in a position where we know some things and some things we do not know. What we know is what the cabinet did with respect to the proclamation. What we know is what the Prime Minister tells us, that a Minister of Government, singular in that respect, is responsible for the outcome. That minister has been walking around this country telling every man and his dog who would listen that he is not guilty as charged by the Prime Minister. He was dismissed from the cabinet for lying to the cabinet. He is making it quite clear in a variety of statements and ongoing statements that he is not guilty of that allegation. He has also made it quite clear that there are others in the cabinet who are more guilty than he is and ought to have been held accountable more than he was. This is an action of a body, the singular body in the country, where they are joint and severally bound on the actions of the minister and the actions of the cabinet. And had this matter not been so serious, it might not have been taken so seriously. But do not lose sight of the fact that what we are talking about here is an undermining of the rule of law with the assistance of the cabinet, where persons have, by their favors of the state, through the cabinet, been allowed to evade their day in court. That is the seriousness of the matter. And that is why the president has been kept apprised of what we know and what we expect. And that is why we expect the president to inform us as a population as to what the details of this matter. It is unacceptable for the Prime Minister to be seen or to be deemed to be seen to have not responded to the president on the basis that she has already dealt with the matter. It is also unacceptable in this crisis for the president to accept any such position from any prime minister, because the population has in place legal protection against this travesty. So the doors of the court are open for all officers who find themselves in this situation that I just described. And we at the opposition expect that if the president would have received from the Prime Minister any statement as published, and so far it has gone unrefuted, that the Prime Minister is taking the position that it has already been dealt with, then the president now has a duty to forward this matter to the judiciary for adjudication on the details of Section 34, where the courts will examine whether the officers involved, namely the Prime Minister, would have discharged her duty under the requirements of Section 81. Because you see, we can't accept this precedent. And I'm speaking here against the background of not seeing the content of what the president wrote to the Prime Minister, or what the Prime Minister would have said to the president in no reply. However, what has been published and is for public digestion from sources in the government, and what we have put to the president, and where he has gone under Section 81, it is reasonable for us to assume that this problem exists until such time as we are brought into the picture and given the details of what transpires in the text of the book. What is unacceptable is for us to believe that this matter can end in this way, where office holders can attempt to invoke provisions of the Constitution, and other office holders can determine that I am not going to respond to that, and that the beneficiaries of the cabinet's improper action can vote, and that the cabinet could stand accused of the conduct that it has been accused of, and that we can now be advised, as we knew before, that this matter remains unresolved. What is undisputed is that the details of the purpose for the government bringing Clause 34 into operation remain unanswered and unknown, and we are demanding that answer. We demanded the answer of the government, we didn't get it in the parliament. The Prime Minister addressed the country, she didn't give it to us. We marched in the street, she didn't give it to us. We went to the acting president, we didn't get it. We've gone to the substantive president with additional information. We haven't got it. The matter remains unresolved. And we will leave no stone unturned. As long as we have remedies available to us, we will resort to those remedies. And we expect now that we have gone to the president and that the president has gone to the prime minister, that the prime minister's intransigence ought not to be tolerated by this population and ought to become no precedent for the behavior of any officer. Because I can give you a couple of examples. If something is going wrong in your home and the police officer assumes that, let's say, there's child abuse or domestic violence taking place within the walls of your home, and you come to the gate and say to the policeman, I have dealt with it. When he suspects that you are the perpetrator, is he to accept from you that the matter has been dealt with and therefore should walk off? And for all those who advise us that the acting president has dealt with it, and I'm not here raising the conflict of interest of the acting president, I'm just talking about stages in the process. Why then, when you go to the High Court and a matter is dealt with, and one of the litigants feel dissatisfied, why do we have an appeal court? If it is that to go further on the matter, if you are not satisfied that it has been properly dealt with, if that is to cast aspersion on those who dealt with it at first, why then is there an appeal court in the council? And if it is that office holders can determine that they themselves can rectify allegations made against them, where they can be judge, jury, and executioner in their own cause, why then do we bother to have processes and systems in place to ensure that no man or woman ought to be judge, jury, and executioner? In this case, I want the population to not lose sight of the fact that the allegation is being made against the Prime Minister and her cabinet. And if she is to properly respond to the President, it is already out of the question that she can say, I have dealt with the matter, when we already know that we have not got satisfactory answers. But more importantly, if the country's records are to be properly written, and that there is to be peace, quiet, and good order in this country, in a situation like this, the persons involved in this matter are to be made to answer questions from an independent party. In serious countries, that is how it is done. We have seen presidents and prime ministers in other countries, when people are serious, having to answer questions about their conduct and the conduct of the administration, not to persecute them, but to ensure that the population gets to the root of the problem, to ensure that there's accountability, and more importantly, to ensure that there is no repetition of it. So here in Trinidad and Tobago, where we are trying to build a nation, we are not prepared to accept from office holders their self-serving interpretation. And they can denigrate those who are involved in pressing for answers as much as they like. But the bottom line is, they cannot tell us that we haven't got an issue and that the issue has not remained unresolved. That is what they cannot tell us. And as long as the issue remains unresolved, we, the people of Trinidad and Tobago, must demand every single effort be made to ensure that we get to the bottom of this. Of course, we know that the perpetrators will put every obstacle in our way, including giving us interpretations as to why we should move on. There will be no moving on as long as we have other remedies available to us. And one of the remedies we had was Section 81. And after that, there will be others, if this matter is not properly ventilated. Now, what do we expect as a people? We expect that the President will advise us as to what the situation is with respect to this development. Certainly, correspondence between senior office holders usually are confidential correspondence. But when the public interest demands it, then for the officers to discharge their responsibilities to the public. Because remember, nobody is in office to serve him or herself. We are all in office to serve the rest of the population. And the way this matter exists and has developed, and the interest in certain quarters to have this matter swept under the carpet and to have it stay dated, the office holders have a duty to report to the population as to the contents of this matter. And I'm making that request now. And I'm requesting of the office holders that the population be taken into their confidence and appropriate statements be made with respect to this matter so that we can know exactly how our constitution is functioning. This is a matter where persons on the outside would look on at Trinidad and Tobago and they will see what we are seeing. That the Prime Minister is requested of the President to provide certain information and that information is not forthcoming or is forthcoming in a way that's unsatisfactory. And that, in some countries, has formed the basis for major developments. In some countries, just the smell of this development is enough to turn country upside down. And of course, if we want to attract investors into our country, against the background of how we have behaved in recent times, we don't want to tell the world that in Trinidad and Tobago, we operate our business where the Prime Minister can tell the President to go to hell. That is not